people need to understand that this case now is probably more important than it ever was, in the fact that they can bring this back at any time. These mandates were only ever suspended. They weren't taken away. They weren't written off and dismissed. They've been suspended. And at any time, they can bring this back. And if any of this legislation that they're talking about comes through now, we could all be literally mandated to be taking vaccines again as early as next year.
In this particular case, these issues affect every single Canadian, not just those Canadians that chose not to have a COVID-19 vaccine.
It has been 4 years since then Prime Minister Justin Trudeau introduced a travel ban that barred millions of Canadians from boarding planes or trains without the then still in clinical trials COVID-19 shot. And 2 ordinary men, not politicians or activists, refused to let that chapter close quietly. Carl Harrison and Sean Ricard are taking the government to federal court, determined to ensure the charter infringements from that travel mandate never happens again. Their latest case will be heard this Monday, November 3rd in Toronto, but to understand how it began, we have to rewind to 2021, when 2 Canadians, frustrated by government overreach, decided to act.
Back in 2021, and I kind of noticed that Sean was wanting to go ahead with a court action on this, and I saw him on Twitter actually at the time, and contacted him, and that's how we got to know each other right at the start. Was very, very quickly.
Yeah, and I think we were angry. We were very angry at the time. I myself, I was a permanent resident here in Canada at the time, had been for like 35 years or 34 years at that point. I'm now a citizen, of course, but and the fact that we weren't able to leave the country to go home and visit, parents who weren't doing very well, and just the fact that we weren't allowed to leave the country in general was very egregious, seemed somewhat tyrannical. And I just made a decision to do what I could in any way I could to push back on it. And that's when we got in touch with Sam, our lawyer. We actually met him through Roman Baba. Got introduced to him through Roman Baba, who I had a brief conversation with. Put me on to Sam. We hit it off right away, and the rest is history. Within days, I had launched a fundraising campaign online, and we raised enough funds to file a lawsuit.
They were the first of 4 lawsuits of this kind to be filed, joined by high-profile challenges from former Newfoundland Premier Brian Peckford and People's Party of Canada leader Maxime Bernier. Although all cases were heard together and ultimately ruled moot once the mandates were lifted, Carl and Sean's fight didn't end there.
It's not actually an appeal from the first case. So I think it's important to understand that the first cases that were launched in 2021 were administrative cases, and all 4 of them went forward together, as we say, but all of them ended effectively after around June 22. The cases themselves were successful in forcing David Lametti to reconsider the position and advise the cabinet to suspend the vaccine requirement for travel, and that was a fantastic result at the time, and that happened because of evidence that came out in discovery from government witnesses, which was adverse to their case. So that case then went through the process that you referred to, being made moot by the government. They filed a motion to render them moot because the issue was, in their view, no longer live. And so that went through a process in the Court of Appeal where we challenged that, and the Court of Appeal upheld the federal court's decision that the issues were in fact moot. Now I know that Brian Peckford and Maxime Bernier pursued it to the Supreme Court, but it wasn't taken up by the Supreme Court. We chose not to do that because we were concerned about an adverse result coming out of the Supreme Court. We know Brian and Maxime, so and their lawyers. We discussed it at the time, but we chose not to go ahead with that. What we chose to do was something that we discussed with the government earlier in the federal court, which was to challenge it afresh on the basis of filing a claim effectively for damages, an action for damages, which is not impacted by mootness. There's whatever happens from here, the government will not be able to file a motion to render the action inactive, basically. So we've gone down that road. So it's a fresh case. And what Justice Trent Horn was doing was looking at a government's motion to strike the entire action that Sean and I had brought, and that was heard in 2024. We're challenging the government on 4 sections of the Charter. Section 6 being the mobility, the ability to travel in and out of the country and between provinces, etc. Section 7, which is basically the key area is bodily autonomy. Can I decide what I'm going to put in my body or not, and without recourse? Section 12, cruel and unusual punishment, which we think is a live issue in this case, but it's normally used in criminal cases. And Section 15, which is really important, can we effectively define the so-called unvaccinated as a protected class of people in Canada, alongside many other protected classes under Section 15.
As this appeal moves forward on the removal of Section 7, which is bodily autonomy, and Section 12, cruel and unusual punishment, Harrison emphasizes a key point. Canadians should never have to sacrifice one right for another. Exercising their freedom of mobility shouldn't come at the cost of their bodily autonomy.
Canadians have a right to decide whether, in this case, a vaccination, whether they want to have that or not. They shouldn't have to give a reason. If they just say no, they should be able to say, no, I don't want that. And it should have no punishment attached to it of any kind. It should just be a decision that you make. You don't have it, and that's the end of it. You shouldn't lose your job. You shouldn't not be able to travel. You shouldn't be coerced into doing something else. It should be a free decision.
Now, if the government succeeds in striking these charter protections, it would set a dangerous precedent, one that allows coercion to be justified under the ever-flexible and ever-changing banner of a public health emergency. But Harrison and Richard aren't coming empty-handed. They have more than 15,000 pages of evidence from their previous case, proof of what many Canadians have long suspected. The travel mandates were not only unethical and discriminatory, they were driven by politics, not science or public health.
Essentially, the whole government claim had been that Health Canada and Public Health Agency of Canada had been supportive and indeed advised the government to go ahead with this particular measure. They called it one of a series of layers of measures. I think they referred to it as layers of protection. There you go, Tamara, that's what it was. Layers of protection. And what we uncovered in the discovery process through cross-examination of a government worker in the transport, a chief of staff of one of the assistants to the Minister of Transport, was a woman called Jennifer Little, who had put together a little black ops team of 20 people. So just at the time that Justin Trudeau, in about the spring of 2021, was telling everybody that it wasn't a very Canadian thing to do to mandate any kind of vaccine, he was in fact assembling a team of 20 people to put in place a policy to do exactly the opposite of what he was saying. When we cross-examined her, we were also able to get emails. We'd established that in September and October, just before the policy was put in place, these people were frantically emailing the Public Health Agency of Canada and Health Canada, basically saying, look, we've got a policy that's going to be going into place in a couple of weeks. Can we have some science to wrap around it? And the Public Health Agency of Canada was saying, no, we don't have any for you. And so the idea that Public Health Agency of Canada or Health Canada had advised the government to do this or in any way supported them in it was a complete lie, frankly, and just made up. So that's the bit of evidence I think they particularly don't like. It's rather stark, and it points to the fact that the Prime Minister, in my view, was lying. And I think that the Minister of Transport was lying, and all of them, anybody who said that, whether it be Theresa Tam or anybody else, basically just lying.
The person who under cross-examination revealed that little snippet was a lady by the name of Dr. Celia Lorenko. She was I forget her title at the time, but essentially she was responsible for the approval and rollout of all vaccines in Canada. Not many people had heard her name. They knew Theresa Tam, but Dr. Celia Lorenko was kind of working in the background and making all of these decisions. And it was her testimony under cross-examination that led us to what Carl had just discussed about the fact that PHAC and Health Canada had not provided them with any evidence at all or any scientific evidence to support what they wanted to do when Trudeau decided to create his wedge issue during the election.
Now, the appeal will be heard on November 3rd, as mentioned, at the federal court in Toronto, and depending on the outcome, it could redefine Canadians' charter protections.
It can't be correct that Canadians have to choose between charter rights and sacrifice one in order to get the other. There are countless examples of why that would be wrong, and we think that's something that it's a key point that the courts need to address. And they need to make it clear to government that that's not acceptable, and Canadians don't have to choose with one right over another, which is what happened. So that's why it's important that we think we have a discussion in court about both of those charter rights rather than one or the other, which is clearly what the government would prefer. They'd like to perhaps isolate one and try and pick that off on its own. And they think the two together are quite awkward for them. I'm sure if we were not to succeed on the appeal and went to trial just with Section 6, we would probably want to talk about Section 7. I'm sure the government will throw everything at it to try and stop us from doing that. We have to be careful also that we don't go all the way through this process and come out with the wrong decision. I mean, being flamboyant in court's not a particularly good idea, and grandstanding can end up with the wrong result. So having your day in court can be very expensive if you get it wrong. So we're very cautious of that as well. And we have been throughout the nearly 4 years that we've been doing this. We are cautious about, we don't just want a day in court to throw everything at it and then find out that we do Canadians an injustice by allowing the government to create a precedent, a legal authority that's adverse to Canadians' interests. So that's just a cautionary note, and we'll always be very careful about that.
But if the government can bury certain sections of the Charter and arguably justify doing so, what door does that open for future coercion and future governance?
Dr. Regina Watteau's work, who I believe you're familiar with as well, regarding David Fistman and his role in the mandates and the fraudulent data that they put out and all conspired with. But it's important that people understand the frustrations, I guess, lie with us in the fact that a lot of the heavier hitters in the Conservative Party have been very quiet on this. And I get why they are right now. I completely understand how the whole chess game works, but I do still get frustrated about it. But all through the last 4 years, no one in a front bench position has come out and raised this and brought it up. And to me, that's very, very frustrating and a little disheartening. And I think we need to have more support. And it goes back to what you were just saying with regard to how would this affect another government. A lot of people are forgetting about it. And I think it's very important for your viewers and especially those 5 to 6 million people whose lives were negatively impacted by these tyrannical, vile mandates, understand that with a lot of the new legislation that they're trying to push through now, Bill C9, C8, and sort of questions being asked about whether vaccines should be mandated again, even flu shots and that type of thing. People need to understand that this case now is probably more important than it ever was, in the fact that they can bring this back at any time. These mandates were only ever suspended. They weren't taken away. They weren't written off and dismissed. They've been suspended. And at any time they can bring this back. And if any of this legislation that they're talking about comes through now, we could all be literally mandated to be taking vaccines again as early as next year.
And that's the crux of it. The case isn't just about vaccines. It's about preventing any government from weaponizing the so-called greater good to strip away your fundamental rights.
In this particular case, these issues affect every single Canadian, not just those Canadians that chose not to have a COVID-19 vaccine. And not sure that's coming across. We saw that with the Freedom Convoy, the Freedom Convoy were protesting a matter that ought to have been of concern to every single Canadian. It just happened to be about this issue at that time. And that's what our case is about. Our case really is about people's right to enjoy their charter rights free of this kind of government coercion. If the government is able to coerce people in the way it did around the COVID-19 vaccines, then another government will do the same on something else. And that something else may be an issue that's a darling issue for people on the left of politics at the moment at some point in time. They need to understand that and look at cases like the one that Sean and I have brought as representing their interests too. And I'm not sure that message is really getting through to a lot of Canadians. They tend to see this as an issue they don't agree with because they didn't agree with perhaps the reason that the Freedom Convoy were in Ottawa. And that's where the government is getting away with it. It's the wedge issue again, but in a different form. It's splitting people up on something which affects all of them. People, all Canadians should at all times have the right to decide what happens to their body. The government should not have a say in it.
The bottom line is that if a precedent is not set, then any government moving forward would be free to do the same thing again. And as Carl correctly pointed out, not necessarily on a vaccine issue. It could be any issue at all that could affect either those on the left or on the right.
People can register to attend online via Zoom. The details are shared on Richard's X account or at the Institute for Freedom and Justice. He's calling on people to show up and to show the court that this issue is not moot, because public interest still matters, and the courts can make it clear that Canadians' rights matter more than any politician's ambitions. For Rebel News, I'm Tamara Ugolini. To find evidence contrary to that safe and effective narrative we heard throughout the last few years, head on over to nomoreshots.ca. There you can support this kind of journalism, and you can also sign a form email to send to our Federal Minister of Health arguing that she should revoke market authorization for these injections. All of that and more at nomoreshots.ca.